Thank you, Mr. Chair, and thank you to our witnesses for joining the committee today and for their very informative statement. There's certainly a lot that has been mentioned, and it's insightful, and I'm sure that our committee will be asking you to elaborate on some of that. Firstly, in your statement, you mentioned redactions and that it's clear that it's up to your office to vet them. And I'm hoping you could elaborate on your office's redaction process.
We've, as set out in my statement, we are setting out a team to review the documents, to look at if there are some proposed redactions from the government, really to go page by page, line by line, and making sure that the grounds that the House has identified in terms of the appropriate areas for redactions, that those are made, and that the information that needs to be kept confidential is kept confidential. So we would very much go about that in a very meticulous and very careful manner.
Okay, thank you. Are there standards for redactions enshrined in the Canadian law, and can you expand on the obligations to redact under the Privacy Act?
Well, in this context, the order and obligations to redact do not come from the Privacy Act, but they come from the House's constitutional authority to seek documents and to determine the manner in which and the public interest considerations that ought to be applied. And so we can look to those statutes if there are similar concepts that are found in those statutes. It can be a guide, but at the end of the day, the ultimate ground is the one that the House has adopted. And so this is what we would look to first and foremost, but certainly there are legislation, the Privacy Act, Emergencies Act, they're related concepts, and we would look to see how those are consistent and helpful to apply the House's criteria.
Thank you. And I understand that in addition to the Privacy Act, there are obligations within the Access to Information Act as well. And are these different than those that are outlined in the Privacy Act?
These are obligations that fall on the government and the executive in terms of what documents can be requested by Canadians, the grounds for redactions, the process for complaints. There are obligations on Parliament, the House itself, in terms of proactive disclosures, and there are rights for the protection of private information. But these statutes are distinct from the House's authority under the Constitution to seek and receive information from witnesses, testimony and documents, and to determine the grounds therefore. So those statutes are not limits to what the committee can request. Obviously, they provide for very important public interest principles that should be considered, but ultimately the committee and the House have the last word.
Can you give us more information about the obligations required under the Access to Information Act?
The obligations required on the government or on the House, because as counsel to the House and as counsel to the committee, I would say that the obligations the obligations do not apply to the House and to the committee. So these would be questions really for the government as to what it is required to do under those statutes, and the government would be best placed really to highlight its obligations in this respect.
Okay, if I could just come back to the redaction process. So imagine some boxes full of documents arrive at your office or electronically. What are the steps that you would be going through to determine what should or shouldn't be redacted? And are these items then referred to the government, or has the government highlighted areas that they feel should be redacted and you make the decision? So how is that going to work, just so that I can get a better understanding of that?
Well, one of the unknowns is we have not received the documents yet. So one of the things we do not know is whether the government will have proposed redactions or not. So if they have, then we would look to those, and we would expect to be able to see behind those redactions, to what is being proposed to be redacted, what's the information behind it, and then comparing that to the grounds so that the House has allowed. Is this something that is personal privacy information? Is this something related to national security? Is this information, the disclosure of which could reasonably be expected to interfere with contractual negotiations? So these are really the guiding principles, and we would look at that. If there are no proposed redactions, we would nonetheless look at the documents ourselves to see, is there information there that is problematic? But in terms of the national security and the interference with contracts involving the government of Canada, we would expect that the government would be raising concerns on those, and we would look at those.
Yep. Given the prioritization, I haven't seen the details on what was proposed or adopted just today. Would the focus on the vaccines, et cetera, be one of the areas where there might be a higher risk of interfering with contractual negotiations?
Well, in its motion, the House really linked the vaccine development and the contractual negotiation. So it said that this ground of information, the disclosure of which could reasonably be expected to interfere, would apply with respect to paragraph Y. And paragraph Y is the paragraph on the vaccine task force. So I think that the House accepted and understood that when you're dealing with this vaccine development issue, there is a risk that there be contractual information that needs to be kept confidential so that it doesn't harm that relationship between the government and the vaccine developers. So the House has agreed that this is a valid reason to keep information confidential. So if the prioritization results in those types of documents being looked at first, I would expect to see that ground come up. I would expect that this is where you would see this issue being raised as information that should be kept confidential.
So could that?
Thank you, Mr. Van Benen.
Thank you.